I want to start by saying that if you follow this EFCC thing from beginning, there is always controversy in every appointment. And so also is their exit, starting from the first person, Uhuru Badu, the last man, now that is Bawa. The appointment always generate controversies and a lot of discussions on television. And at the end, the dust will settle down. I'm very happy that he has quoted a particular section, and that is that section 2 of the EFCC Act. We look at what are the requirements for you to be a chairman of EFCC. You must be a serving or retired member of the security agency or law enforcement agency. Security or law enforcement agency. And everyone agrees that this man that has just been appointed was once a worker within a security enforcement agency, and that is EFCC.
You use worker advisedly?
Yeah, yes, officer. He was an officer, chief of staff, or at the time he became the secretary of that particular agency. Then secondly, he must be of a status of not less than, not below the rank of assistant commissioner of police. Then the third qualification is that he must have or possess cognate experience of 15 years. Now that issue of cognate experience is where we're having issue, and the definition is, does that cognate experience mean that he must have it within any of the security or law enforcement agency? The act itself was not specific. If you look at the act, it didn't say that that cognate experience must be garnered from the security or law enforcement agency. Look at it. It didn't say so.
So what about the base interpretation?
No, wait now. So cognate experience, what is the meaning? It is professional experience. And those who are pushing this particular young man as a chairperson gave you reason why they are pushing him. They say, one, he is a lawyer for 22 years. And if you check his profile, that this is a man who has been a compliance regulatory consultant with specialization in fraud management and corporate intelligence. And that he was once a member of the fraud advisory panel in UK. And that he has been to Harvard University in terms of training concerning fraud. And a lawyer for 22 years, and having worked either 5 or 6 years in a security and law enforcement agency, has garnered that cognate experience you are talking about. Since the act itself was not specific as to where that cognate, if you look at it, it didn't say cognate experience within, because that's how, where that particular problem is coming. People were saying, oh, it is within the, law enforcement. It didn't say so. The act itself was specific, was not specific. It said so, 15 years cognate experience. It didn't mention that it must be, that you must continually be in a security agency before you get it. So they now say the man is qualified. Okay, just let me just finish now. He's qualified by virtue of the fact that he has been an officer of law enforcement agency, that he has practiced law in an area that is related to enforcement of law, that's fraud, for more than 15 years now. And that if you put all that together, that qualifies for the cognate experience, because that is the only place they are looking at, this place disqualifies him. But the act itself was not specific as to where the cognate experience should be. When you are looking at interpretation, as my brother has rightly pointed out, there are 3 methods, there are 3 schools. There is a school of, if the law is very clear and unambiguous, give it its literary meaning. Don't ever come with any importation of any other method. Then secondly, if giving a literary interpretation to a legislation will create some level of absurdity, then you apply golden rule. That is the second school of thought. You apply golden rule to avoid absurdity. Then the third one is mischief rule.
What is golden rule, sir?
Golden rule is that you are looking at a piece of legislation now, and you look at it that if you apply literary rule interpretation, it will create some level of absurdity. Then you now look towards a particular interpretation that would now avoid that absurdity.
Which rule are you applying?
Then the third one is what you call mischief rule. You ask yourself, what was the intention, what was the law before the legislators came in? then what was the mischief that the new act now wanted to cure? That is the mischief rule. We are running away from the Nigerian police as being incapable of handling corruption. You created an agency by way of avoiding Nigerian police. And then you now, according to you, says that that particular agency must be run by the same people that you are running away from. Because now really...
That's a different matter.
Yeah, I'm saying...
So which rule did you apply in this?
Now the rule that you will look at for those who are advocating that this man should be, will be this issue of mischief rule and even literary rule. Let me finish.
For this section too,
literary
right?
rule, yes. Now, because the Cognate experience was not specific as to where you are gathering it from. Look at it. Look at the law. Let them bring it on the television. It didn't say Cognate experience within any. It said Cognate, 15 years Cognate experience. Look at it. Look at the law. Let them show it on television, whether there was any particular reference to any law enforcement agent. So my brother has rightly pointed out that if a law is very clear and unambiguous, don't import any other thing other than that literary interpretation. He agrees with me.